Good afternoon, everyone, and welcome to the thorough newspaper analysis for 6th July 2022. Today, we have one editorial which has been taken from the Hindu and is titled Right Intent, Confusing Content. For the second and the third segment of today, we will have the news update and the legal news, which you know are a part of LawSikho's initiative to keep its readers and students updated with the current affairs that is happening in and around of India. Now, this will give you an edge when you sit for your competitive exams, whether it be IBPS, SEBI Grade A, or your judiciary exams. So the article Right Intent Confusing Content talks about the draft e-waste management rules of 2022, which was released back in May 2022 for public comments. Now, last month marked a decade since the e-waste management and handling rules came into effect in India. Now, the rules have been amended a few times since, but this particular draft management rules, which have been released for public comments, somehow goes significantly against the previous regulations that have taken place. So in this article, we will be discussing about what are the major changes that have been proposed and what are their associated pain points, or how do they depart from the vision that was there when they had first made this piece of legislation. So the first change is introduction of a market for e-waste recycling certificates. The second change is the producers now, after this amendment comes into effect, will have to ensure that 60% of their e-waste is recycled by 2023, as opposed to collection of e-waste as a percentage of the quantity of products sold by weight in the market in the previous year. So before this amendment, or before this change that is supposed to be introduced, what used to happen is that e-waste was collected or recycled as a percentage of the quantity of products that was sold in the previous year, and it was done so by measurement of weight. But after this amendment, the procedures have changed, and the producers will now have to ensure that 60% of the e-waste be recycled by the next year, that is 2023. The third change is that a steering committee will be effected so that they can see the overall implementation of the regulations that have been proposed via this amendment. Now, there are associated pain points with this. The first of it is that e-waste recycling markets is unrealistic. Now, if you remember, the first change that we had, or we were talking about, is that introduction of a market for e-waste recycling certificates. So one of the factors that will counter this change is that it is unrealistic. Firstly, the technology that is used in e-waste recycling in India is at a very nascent stage. So this goal seems entirely unrealistic of 60% recycling. Secondly, when we talk of recycling as an entire industry and not just about e-waste, recycling as an entire industry depends a lot on the informal sector, even if we do discount the formal players. So with this EPR framework that is being proposed, the informal sector and the formal players that were playing in the field, they have been completely left out, who have for so long contributed to this entire e-waste recycling framework. So what happens to them? The law is silent on this. The second issue that arises with the draft rules is that experience in European countries have been ignored completely. So studies show that in European countries, it is difficult for regulators to monitor and enforce as compared to collection. The ministry in this regard must specify how the regulated entities shall demonstrate compliance with targets. The third issue that arises is that the steering committee that is being proposed will be effected to oversee the implementation of the regulations. That although the steering committee is made for a noble cause, it severely lacks representation. It is surprising that a representation from science and academia or the civil society organizations was not deemed appropriate when the quorum for the steering committee was proposed. So with this, we move on to the news update. Number one, Punjab appoints V.K. Janjua as the new chief secretary. Almost 3 months after coming to the power, the Aam Aadmi Party or AAP-led BJP government on Tuesday appointed Vijay Kumar Janjua, a 1989 batch Indian Administrative Service officer, as the new chief secretary of the state, and he will be replacing Anirudh Tiwari. Secondly, Sweden and Finland signed protocol to join NATO. Now, if you do remember that Russia was strictly against this, and they had already announced that if Sweden and Finland did move forward to join NATO, there would be consequences. But Sweden and Finland have finally signed the protocol to join NATO, and NATO's 30 allies signed an extension protocol for Finland and Sweden, allowing them to join the nuclear armed alliance once the parliaments ratify the decision. And this will be the most significant expansion of the alliance since the 1990s. Thirdly, Sania Mirza and her Croatian partner Mate Pavic entered into mixed double semifinals at the Wimbledon. Indian tennis ace Sania Mirza and her Croatian partner Mate Pavic advanced to the Wimbledon mixed double semifinals with a hard-fought win over fourth seeds Gabriela Dabrowski and John Peers. Fourthly, Minoti Chatterjee passed away. The former newsreader of All India Radio, Minoti Chatterjee, passed away in New Delhi. Her last rites will be performed at the Lodhi Road crematorium. She was also the former principal of Kamala Nehru College, Delhi University. For the legal updates today, we have trial and appellate court have full discretion to order sentences to run concurrently. And this is held by the Supreme Court in the case of Malkeet Singh Gill versus the state of Chhattisgarh. So the SC observed that the trial court and the appellate court will have full discretion to order sentences for 2 or more offenses at one trial to run concurrently and completely. Secondly, we have the Debt Recovery Tribunal can't go beyond reliefs sought for by a party, and the same has been held by the Gujarat High Court. So in the case of Gujarat State Financial Corporation Limited versus India SME Assets Reconstruction Company Limited and 8 others, the Gujarat High Court made it clear that a debt recovery tribunal or a DRT cannot go beyond and grant prayers that are not even sought by the party before it. So this was all for today. For free study materials and TNA PDF slides, please join our Telegram channel. You can find the link in the description, or you can always go forward and scan the barcode that is given on the screen at the @law test prep. Or you can always follow us on our Instagram channels, LawSikho.judiciary, LawSikho CLAT prep, UGCnet_LawSikho. For any further information, please feel free to visit www.lawsikho.com. Thank you.